For this business update, we'll be talking about our non-renewal of lease form, which is new as of August 23rd. So I hope everybody knows there are basically four types of rental agreements in Massachusetts: a lease, a tenancy at will, a tenant at sufferance, and a license. Landlords basically can't use licenses, so we'll exclude that. And tenancy at will is an eviction term as well, so we don't need to worry about that. This business update is really about the interplay between a lease and a tenancy at will. Now, with your permission, if a renter is allowed to stay on after a lease and the lease doesn't have an auto-renew clause, any tenancy will automatically convert from a lease to a tenancy at will under the same conditions. So if the lease said no smoking and no pets, then the tenancy at will has the same no smoking, no pets restrictions, except the term has gone from the lease term to typically month to month. If you don't have permission as a renter to stay after, you will have to leave. So it's a good idea to find out from the landlord. And that's, as a landlord, it's our job to be explicit when we're thinking about ending a tenancy. So it's good to send our non-renewal of lease form, or it could be any kind of letter. The law doesn't really specify what it has to be. But our non-renewal of lease form gives a lot of food for thought. It reminds renters that they have to leave the place as they found it. It reminds them that they are going to report things that are broken for security deposits or other reasons, and that we as landlords have an obligation to continue to make repairs. So that's good for both sides. If you follow the QR code in this video, you'll go to our non-renewal of lease page where you may already be, and you can download PDF and Word file to customize and send the letter as you would like. Now, there's a legal side note here. Massachusetts law is very particular that leases definitely do end. As a matter of fact, Chapter 239, Section 1A says if a renter tells the landlord that they're definitely not leaving at the end of the lease term, and the landlord has said, I want the lease to end, you can't stay over as a tenant at will, then actually a landlord can bring a case in court before the renter even overstays. And there are very clear restrictions on that. It doesn't apply in every situation, but if you're interested in that, you can look up Chapter 239, Section 1A. Overall, though, remember, as a landlord, we provide housing, and especially if we're a certified Massachusetts landlord, we've made a commitment to engage in dialogue when disputes arise. So if the renter says, I can't leave on that date when my lease ends, I need more time, or in general, if they're not really able to go find housing elsewhere, really think about that lease termination. Make sure you have good reason for doing it. If you can delay a renovation to help somebody have more time to find alternate housing, if that housing is substandard and you need to make repairs or whatever it is, make sure you terminate for good reason, because it's tough out there, and we don't want anyone to get into a situation, renter or landlord, where if we had just waited a little bit and extended the tenancy, things would be better for everybody. When in doubt, consult with an attorney or ask a member on our message boards.